Today we have several hearings cover two idiots pissing off wrong judge, two judges recusing themselves for great reasons. Finally update our favorite Sardian Eric Martin. We start in Con Aut Municipal Court where we have dumbass out on bond for driving without license still thinks, okay, keep getting behind will car.
Look, Mr. Gregory, I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Can you see why I actually like watching this judge? He's fair. He's strict. He runs his courtroom like boss. We stay in his courtroom for next defendant. It's important to know this next hearing about take place in front bunch young kids who are apparently on field trip to courthouse who about learn true meaning of around find out.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say? What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids, in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir,
Get out of here.
He didn't take her case back up that day. I don't think really mattered as she was there turn herself in on bench warrant anyway. Now we had our next case which took place last week in Judge D. Santos' courtroom. This one gets a bit crazy as defendant starts accusing everyone of being racist. Judge DeSanto isn't having any of that.
case number 25W7000388, the state of Michigan versus Bradley Peterson. Okay, counsel, your Mr. Perpenwalk Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably, and at this time I would ask to be allowed to recuse myself from this case, Judge.
This is actually an interesting situation normally. When lawyer ask leave case, typically done by defendant, we see this often in sovereign citizen trials where attorney refuses accept sovereign delusions, so citizen fires his lawyer, hoping next attorney will join him land of crayon-flavored lollipops. However, in this situation, defendant, his attorney have come disagreement in legal strategy. Ultimately, it is defendant's right pursue whatever legal strategy he thinks best, which is why lawyer requesting be recused. I assume he doesn't feel comfortable putting his legal license behind defendant's frivolous motions. I'm sure he feels handicapped having compete with defendant's second legal team from offices of Pro SE. Dick Flute Dumbass.
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on transcript.
Recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts.
Okay.
You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
I don't think it's in your best interest be defending yourself, especially when you don't even know proper procedure for basic, like requesting court transcripts.
If I can request that. Also, I request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just one moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course. I would sure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. And you filed something on January 17th, and you're requesting under 2.003 to dismiss, disqualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Winnebago Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional rights.
That, friends, is bold-faced lie, and one of those weird content creators likes research case history subjects I cover. I especially like when they say factually incorrect statements followed by citing exact proof. I need proof they're lying. So he cited Judge Grant in his case against City of Woodhaven, which led me this federal case in Eastern District, Michigan of Brad Peterson v. Lot of defendants. He literally sued State of Michigan. City of Woodhaven Mayor presiding judge prosecutor for civil rights. Violations he claims city put out PO on him. There is wording and opinion. Suggests this true, however, an appeal he filed after he lost following paragraph appears Peterson's failure object report recommending denial his motion for injunction permits court adopt it. Without further comment, however, court agrees with findings conclusions in that report. That single statement says so much, while saying so little confirms there was counter request for injunction filed by Peterson against injunction filed against him preventing defendant Bradley Peterson from violating sign ordinance in City of Woodhaven also confirms even if you would have appealed injunction, they would have ruled against you anyways. Magistrate Grant did dismiss several cases with his ruling, but they were pretty much all cases he filed. They did not dismiss city's injunction against him, as he stated. Just put conclusion on this little side story in December 2024. Appellant judge made final ruling dismissing all charges against state its co-defendants with prejudice. Stop lying, you're too old for that.
And I believe that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir,
I'm with you, man.
the allegation is that that you assaulted, resisted, obstructed a police officer causing injury, and trespassed.
That's just an allegation.
You're correct. You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they are allegations only.
Yeah, you need to read the whole thing of it, just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
But none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of mine.
I'm sure it's filled with lots beautiful stick figures, brightly colored construction paper, but who cares? You can write as many non-European constitutions as you want, still doesn't change fact while you're in state of Michigan, you're bound by both federal law, state law, as granted to state of Michigan by 10th Amendment United States Constitution.
If I followed your white laws, I follow them, and then you stomp on me when I follow your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now. I'm not 100 years old, so do not accuse me of stomping on anything.
Well,
let's be very clear on that.
Yeah, well, okay. Yeah, don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven, though, and now you condemning me for it because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also took an oath to uphold every citizen's constitutional right to public protest. But you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right. So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did?
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse, and it was okay. You should have arrested me then. When I go to your schools and you wind out, when I go to schools and you wind out, you should arrest me. But you're not going to. It's not right.
This guy is such professional victim. He's actually in courtroom arguing with judge why they didn't arrest him for expressing his constitutionally protected rights.
Let me just clarify. I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights, and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, This is considered pre-trial.
I know what this is.
So
I've
I
been
don't-
through your system before.
So
Also, Your Honor, I've asked, if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment,
Here.
just one moment, just one moment, please. This court, sir, has to take the allegations, and there's a process.
Like, I don't know it. I know your process. I've been down your roads before. But
I don't know
I'm
what
15.
roads of mine you've been down, sir.
I'm 15,
But you've
the
been here,
defendant-
excuse me, you've been here in this court a number of times,
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you've even
That's
stated that
not
yourself.
all entirely true.
Hold on, sir, I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir, I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postponed. The City of
that
Woodhaven
the
wrote a
federal one?
violation. No, they wrote violations on me for posted signs in this case, in other cases. Because I was protesting in the City of Woodhaven.
Okay.
But on that, the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid, I'm not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year?
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid. I made sure that there was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway, I'm 15, the defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way it's impartial. It's where another judge can look at it and not just yourself. And apparently you want to hold this case for a reason. And I believe that you in the City of Woodhaven, the state of Michigan is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, there's something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the City of Woodhaven because of allegations that I committed assault against the police officer. You guys don't even know me.
Sir, okay, stop right there, please, just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I am obligated, whether I want to or not, to sit and preside over the matter. I am the chief judge of this court, and so I don't find that there's a basis at this point for me to disqualify myself. However, you certainly have the right to request the State Court Administrative Office can review that. That's absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this, because if you don't want to dismiss yourself from this case, we got a problem right there. Because
There's not a problem, sir. I have a responsibility.
The city would have.
Sir, I have a responsibility. The matter is transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here, I don't know. I can ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So, just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the City of Woodhaven. I think the judge Ken Bash or something like that. He might be up there somewhere. He's retired now. You guys did me the same thing, same way you did.
You guys, I wasn't here.
Well, that's what I'm trying to say. Your system.
It's not her system, it's our system. We people elect legislators, create rules, regulations. We all socially contract follow moment we start enjoying amenities our society. You may not like system, but system is not designed for individuals like yourself be satisfied. It's designed for governance citizens that live within its jurisdiction. If you don't like it, you can leave anytime you want.
You wasn't here, you're not 100 years old.
It's not my system. It's the system of the country. It's the entire system. You keep accusing this court that I'm 100 years old and I've been oppressing things for 100 years, that it's my system.
Well, I'm saying
I didn't arrest you. That is not
it's your system,
my system.
and regardless, this is your system. It's not mine.
It is yours. It's
No,
not.
it's not. I'm Native Indian African. I'm not even a citizen.
No.
No, I'm a prisoner in my own country because of you white people. Y'all need to go back home where you guys come from.
Yet Judge Santo, go back where you came from, like your home in Michigan. In 45 plus years I've lived on earth. There's one thing I've learned about society that will never change: those who see racism, everything around them, are most racist, racially divisive people on planet. This is prime example.
Okay, sir. Well, let me just say this. All right. You are accusing this court of being biased and prejudiced.
And racist.
And
Yep.
racist. However, your comments, sir, would seem to suggest otherwise.
Look, why do you raped us, you robbed us, and you murdered us legally?
Stop right
Everything
there.
that you people
Stop
done is
right
been legal.
there. It's not you. I did not do that.
You're the system.
Do not put that on me. But here's what I'm going to do, sir. I'm going to grant your request. And this court's going to disqualify itself, and you can figure out which other court's going to handle this matter after the state court administrator sends wherever it's got to send, whatever it has to send.
Thank
So, because at this point, I am not going to stay here, take the abuse from you and your allegations, which are completely false and unbased. This court, myself, did not do anything that you're accusing me of doing, at all. I wasn't even around at that point. So we're going off the record. You can step outside in the lobby. Somebody will give you the next stuff you have to do.
And I'll give you a call, Mr. Kelly. Thank you very much for helping me.
That's all.
Yes.
There'll be another judge assigned.
So am I free to leave, or do I gotta get paperwork or something?
I believe that you're all set, sir.
Well, thank you. You have a good weekend and a good year. Thank you.
Good luck to you, sir.
I don't want to violate none of you guys' laws.
Yeah, well, you keep following that European Constitution, you'll be all right. Keep doing things the way you've been doing them all your life. You're going to end up spending some time jail. I know there's going to be a lot of people in comments section who think Judge D. Santos shouldn't have recused herself. I personally disagree, because she was clearly pissed off about blatantly false allegations made against her. Last thing any of you should ever want is let her emotions serve injustice instead justice either. Let guilty man walk, send innocent man jail. This reminds me another one of my favorite judges who recused himself after Soft threatened him on record, Judge Slavin.
So your case, you're going to get notice in the mail for when your trial date is, and that's going to be with Judge Shackelford, because I did have to recuse myself because you had made threats against me. And I didn't feel comfortable with you being in my presence, the case you'll be getting notice of when your case will be heard. All right.
Well, just to clarify, there were no threats made on the record.
So, all right, no, not on the record. You did so on YouTube, and so you're
I say I'm gonna throw truth bombs like.
You put pictures of bombs on me, and the judge is going to find out when things go off or whatever. So you know what? If you want to make threats against me, listen, sir. You would never be able to handle a threat against me. I'm just telling you. So goodbye. You're
believing what?
Bye. So when people make threats against you, I'm just going to tell you right now, and anybody else who's watching out there, I don't take threats very kindly. And you know what? I take them very seriously. And you know what? As a man, as a free man, as a man who is an American, I know what my rights are. And I exercise my rights. Freedom of speech. That's one of them. I like freedom of speech. Freedom of assembly. I like to hang out with people who I like to hang out with. Good people. Good, strong people who are, salt of the earth, people like Mike Tinney, good friend of mine. I also exercise my Second Amendment right, and I'm well aware how to do so. So, I highly suggest you don't make threats against me, because I do have a right to defend myself.
Amen, Judge Slavin. Again, I personally believe his decision to recuse himself was correct. He realized his personal beliefs made him feel certain way about breathing brain donor, known as broken system, broken tooth. He might do something drastic, which might violate tooth's rights. Now, for our next hearing, we stay in Judge Slavin's courtroom. However, Judge Slavin had day off. Another judge had deal with America's favorite sovereign, ass hat Eric Martin, who manages set speedrun world record fastest time for having his bond revoked.
All right, yeah, this is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Tarrant on behalf of Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N, family, a private living man, one of the sovereign people.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled out, can't believe his name.
Yeah, you're Eric Martin, in other words.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now, and under the applicable court rule on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from, I believe it's the $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he's told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released under the Michigan court rules.
Eric Martin, public defender, just made really good argument for his PR release from custody because according to MCR 6.4, defendant on 93-day misdemeanor has right be released on PR bond after 28 straight days incarceration. That comes with some caveats that we'll get to in a bit.
Yeah, do we have the prosecutor available on this matter?
He was just in here. I did tell him I would be raising this issue.
Okay. Yeah, I'd like to hear from the prosecutor on it.
He's in the main session now, Judge.
So what I got to say then, before the prosecutor gets a chance to say something?
So, this is on the Eric Martin case, charging as a misdemeanor domestic violence, originally placed on a personal bond. My understanding that he violated bond, and the bond was reset at $2,000 cash. because he violated, I think, by having, I think it was, correct me if I'm wrong, contact with the victim?
Judge, Alex Ringer for the people, P number PH6590. Judge, it's the people's understanding that the defendant cannot go to that address and went to that address, and he was then taken into custody because of that address that he went to, he's not allowed to go to.
So, yeah, and so, Mr. Darren, you want to renew your argument about time period of being in custody on a misdemeanor case and why bond should be personal bond?
Yeah, Your Honor. Just, I'll just briefly, as I did kind of let the prosecutor know, he's been incarcerated for, by my count, 38 days since December 17th when he was picked up. And he's now, it'll be 38 days, 39 after tonight. The court rule states that after 28 days, he can be released on a personal recognizance bond. There are most of the reasons that it would be denied is based on some sort of delay that's attributable to the defense. I know he's had a couple attorneys, but there's always been the court dates have been set. So I think he would be eligible for the release on the personal recognizance bond.
We have something to say, Your Honor.
Shut up, Eric, that public defender, has done more for you in last 5 minutes than you've done for yourself in last 5 decades.
Just 1 minute, Mr. Martin. We'll hear from the prosecutor.
Yes, Judge, the people, the victim has been sending conversation talks to the victim advocate, and the people would ask if the defendant is released on a bond that the defendant would have a tether placed on the defendant, therefore that it can be rest assured that the defendant makes no contact with the complaining witness in this matter.
All right. Yeah, did you want to be heard, Mr. Burton?
Yes, okay, now, I want to add, under, not only should, before we get to the bond issue, the cases should be dismissed, which I did file a motion to dismiss already. The court probably just received it, because I sent out not too long ago, like last week. Anyways, under MCR 6.004, subsection C 1 through 6 makes it clear that I have a speedy trial right within 28 days. Since I've been in jail illegally over 28 days, this case should be dismissed based on violation of my speedy trial right. And based on the court rule I just named off, I'll say it again, case everyone heard clearly, MCR 6.004, subsection C 1 through 6, that is the criteria that is to be followed for speedy trial time computations, not the normal excluding Saturdays and Sundays and legal holidays. But it's always been followed wrongly, but it's not, like I said, doesn't apply to speedy trial. So my right to speedy trial has been violated, the case should be dismissed.
Unfortunately for you, it's not going to be dismissed based on speedy trial rights violations, especially based on MCR you just cited, because MCR 6.41 through 6 defines considerable factors for PR release, not dismissal with prejudice. If you look at point 1 of 6, clearly states 28-day rule is taken into account every time defendant files motion requests new lawyer. In fact, lot times you'll find defense attorney will exhaust all their pretrial motions, then invoke on record. That 28-day rule is begin if 10 days into those 28 days attorney files another motion, then 28-day rule resets.
So I want that decided on first before we address the bond issue, because as long as that's granted like it should be, then the bond's no issue. But so once the decision is reached on the motion to dismiss, I just file it now. Then once the decision's on that, then I'll adjust the bond if it's not granted, but that's all I have to say on that for right now.
Yeah, Mr. Orengal?
Yes, Judge, the defendant doesn't get the benefit of picking new counsel, and then when picking new counsel, reach a date where the case will then be dismissed. There's been I believe this is the third or fourth defense counsel representing the defendant, and if it would be then in the court's client to dismiss this outright, then defendants would be able to set the ability to just keep picking new defense counsels, and once they get to 28 days, be able to argue that it wasn't a speedy trial and then have the matter dismissed. So it's the people's argument that the case should remain as charged, and addressing bond again, that if the defendant is released on personal bond, it's put on a tether.
I gotta talk to.
Okay, now, what he just said was, I was gonna say it's irrelevant nonsense. I've been in jail since the 14th of December. That's a fact, cannot be disputed. I've been in jail since the 14th of December is when I was arrested by Taylor Cops illegally, based on no evidence, based on my brother's lying allegation that I sold him, which is all it is, it's a lying allegation. But anyways, the fact is I've been in jail on the 14th till now. It's over 28 days. The court ruled again, NCR 6.004, subsection C, 1 through 6, makes it clear when you are in jail consistently for 28 days, your right to speedy trial has been violated. It demands calls for the case to be dismissed. Simple as that.
I don't know if Eric Martin suffers from delusions or autism. Nowhere in MCR 6.04C1 through 6 does it say, who weasels his way 29th day deserves dismissal. It does say you are entitled PR release. Even that comes with some considerations like whether you're going return court, whether defendant is danger public. You, Mr. Martin, refused to abide by no contact order, so you are both candidate for bail, jumping, danger your immediate family. Let's hear from Eric Martin's victim, his own brother.
I'm supposed to be the defendant or the plaintiff or whatever. Hello?
All right.
Nobody even talked to me. Hello?
All right, so thank you. Yeah, who's speaking now?
This is Kurt Martin, the brother.
All right, did you want to comment on this whole matter at this time, Mr. Martin?
No, I mean, no. I couldn't even, I didn't even know it was today, the court. I thought it was yesterday, and I was just called by the prosecutor that it's going on today. I've been hospitalized, and I'm now in a facility that's taking care of me, and so I don't have nothing really to comment about. I mean...
All right, very good.
I just want to make sure that you can see me and I was heard, because there's nobody that
All right, well, thank you, Mr. Kurt Martin. So, all right, I'm denying the defendant's motion to dismiss based upon his changing of defense attorneys. The delays appear to be, to a great measure, caused by him by violating his bond conditions and repeatedly changing attorneys. That motion is denied. I will allow a personal bond in the case of $2,500, conditional upon a GPS tether and preventing the defendant from going within 1 mile of the victim's residence or having any contact with the victim, as well as no alcohol or illegal controlled substances, coming to court when required, advising the court of changes of address or telephone number, and not leaving the state without the consent of the court, not to possess any weapons and or firearms. And we'll give you another date for court. That'll be, we're going to need an address for you or phone number, Mr. Eric Martin, for that hearing. Or you can come to the court and get that date. Come to the court and get that date, Mr. Eric.
I have objections to, can I talk now? I have objections to your order now. Can I make objections now to your order?
Why are you talking? You've already got what you wanted. There is literally nothing you can say right now. Going improve your situation, Eric Martin, is different breed than rest us about break record for fastest bond revocation in history.
I said I have objections to your order. Now, first of all, the in objection to your order, no dealings being attributed to me switching attorneys. That's false. Okay? I have not intentionally said, give me this attorney over that attorney. Whatever they did, that's what they did. You know what I mean? I told Slavin from the jump, yes, I want an attorney. Nothing is attributable to me. So the motion should have been granted, number one. Number two, even if you still don't grant the motion to dismiss like you're supposed to, I object to the bond condition. They violate my due process rights. I don't lose my due process right to be in my house. I've been living there for 32 years. The house I've been living there for 32 years, regardless of whether it's mine or not, okay?
Do you understand? I understand your position, Mr. Martin. Are you telling me that you're unable to abide by my bond conditions?
That's right, because I have
65.28 seconds. It took him 65.2 seconds to destroy his own dreams of freedom. Eric, you just one donkey of a day.
All right, Mr. Martin.
I have no house to go to. And it violates my due process anyways.
Yes. So Mr. Martin is telling me preemptively he will not abide by those bond conditions. Therefore, I am going to change the bond back to the original bond and keep it at the cash bond because he poses a serious threat to the community. He's already demonstrated he won't comply with the bond conditions. And now he's preemptively telling me that he will not comply with the bond conditions I've just set. So therefore, your bond is remaining at what it was before, the cash bond. We will reset the pretrial conference and a notice will be sent out for that next pretrial conference. Same bond conditions. And
that violates my due process. I want to appeal this now. I want to appeal this to the Court of Appeals ASAP. It all violates my due process. It violates my...
All right, thank you. That's going to end the hearing.
Bye, have a great time. That's end video. I have a lot of content coming out in next couple weeks, including finally being positioned to talk about sovereign citizen Karen, who sued me in federal court. Lost. You don't want to miss it. If you like video, hit like button. If you disliked, hit dislike. Don't forget, leave comment below, subscribe with notifications on so you don't miss any of my content. Team Skeptic, I'm out. Here we go.